100 of the Young Slime Life trial. Day 100. This is the longest trial in Georgia history. And I don't know if you've been following along with it, but I have. And today is significant because the judge is now going to share the transcript of the ex parte meeting that he held with Woody, one of the witnesses who had immunity that was supposed to testify against Young Thug. He had a secret meeting with Woody's attorney, and a few other people. The defense team was not included in that meeting, which is what made it ex parte, which we all know that ex parte means absolutely not. What are you doing? You can't do that. So I guess the words chief and the word judge got to his head, and he just went too far and just started breaking laws while he's trying to emit justice. It made no sense. Anyway, the point is that he's now going to share with the defense team what was said in that ex parte meeting. And he also comes up with a few other things. But the most important thing I want you to listen to when you watch this video is listen to how Judge Glanville continues to defend himself, how he gives excuses, reasons, and explanations for doing improper things in the courtroom, and how petty he is. This dude is so petty. He's still trying to justify how he needed to know who it was. And we all know now that Kayla Bumpus, who was Woody's attorney, she was the one who blew up the spot and told the defense team what Judge Glanville was up to. So now everything is on hold. He had a motion for her to be trying to put her in the order of contempt. He did all of that. So everything is on hold for now. But does that mean that the defense team, all those guys, are they all in, are they going to stay in custody? Are they out? I know he said something about that the jurors were not excused. So are they like going to be away from home until all that part gets figured out? The case is basically on pause. Nothing's going to be done until another judge visits the recusal trial for the ex parte meeting that he had illegally. Anyway, listen to how Judge Glanville gets super petty, trying to defend himself. Most importantly, he feels vindicated. I feel like he's acting like he's vindicated because he knew somebody ratted out what he was trying to secretly do. He is also kind of making it clear that he knows who that person was who ratted him out, because he went as far as checking the video cameras. He checked the cameras and found out it was Woody's attorney. Anyway, check out the video and let me know what you think in the comments. Welcome, 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 my friends. I am Bushes99, and if you haven't already, let's go ahead and hit that like button just because it's me, your girl. And also subscribe, and you'll get a heads up every time I'm out here doing my thing. So without further delay, let's get into the video.
All right, folks. As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as Courts 2. So the transcript will be Court 1. His immunity agreement, Mr. Copeland's, will be Court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court's already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment. Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage, and only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves an pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing, or this particular conference in front of the court, is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had and the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. They cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They say see United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got the citation for that being 439 U.S. 913, Although an ex parte conference to discuss threats against witnesses is proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed, and second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd, 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, are disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on looking at the case law, that that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, then the court lastly took into consideration Tarleton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Steele's raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees a criminal defendant the right to be present and see, hear all the proceedings which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow. The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sir, as a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that, so we will not be holding that particular hearing, okay? All right. And then then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it, and until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until they're not supposed to come back on Monday until Monday anyway. So I will I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay? All right. Ms. Novi, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? How did you, have you been, I'm asking you at this point in time, could you state for the record how it is that you don't think you have a conflict? Because you did represent one of the co-accused in this case, correct?
I did.
Okay.
I did. He's been discharged. Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up. And what happened in the ex parte proceeding, we're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is with respect. Is on mute?
Yeah, you're good now. Yeah.
With respect to this court. So, completely different matter, and now we're dealing with a contempt hearing of Ms. Bumpus as opposed to a criminal prosecution of Mr. Kitchens. Completely different, and in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict, I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time. Because you do have knowledge of this particular case, but all right.
Well, I think half of America has knowledge. I said I think half of America has knowledge of this particular case at this point.
But they're not before us at this point in time. So what else did you want to?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchens' case.
All right.
So I'll speak for both of us in that respect since Mr. Garland's not able to be here.
All right.
A couple things that I just wanted to clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one to be spun on the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today.
Okay.
So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay.
So since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you so desire.
That's fine. So
I'm telling you, at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay. All right. Madam, unless you have anything else, you all can be excused. Counsels, I'm going to go ahead and, like I said, work on this particular order. I actually memorialized the order in writing and the motion to recuse. In terms of the sending it to another judge pursuant to 25.1 through 25.7. And we'll see in a little bit, depending upon how it's ruled upon, right? All right.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Miss Alexander, and her team spin that, that's not within my information and purview.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything that could be expedited so that those decisions can be made on the motion to recuse and we can move forward with the trial?
Well, I understand your concern. I think the rules of transfer and recusal are pretty clear that I'm not going to comment on anything that is pending at that point in time. So, hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else? Mr. Steele, you rose just a second ago. Do you want to say something, sir?
No, I thought you were recessed.
Okay. All right. Okay. Then we're in recess and we'll see you in a little bit. Okay. All right, we're in recess.